Hi and welcome back. So today's topic will be hearsay. We'll discuss what it is, its scope, and the exceptional circumstances where hearsay can be admitted as evidence. So enjoy reading with me. The book is a commentary on the Evidence Act by Steve Ouma, second edition, and hearsay starts on page 105 all the way to page 147 if I'm not wrong. Yes. All right. So we start off by understanding first oral evidence, what it is, and what it means when we say direct evidence, because there cannot be hearsay without oral evidence. Yeah. So all facts except the contents of documents may be proved by oral evidence. All right. So oral evidence must in all cases be direct evidence. So the general rule is that for oral evidence to be admissible in a court of law, it has to be direct, meaning I'll give examples here. For example, with reference to a fact that you saw, direct evidence means the evidence of a person who says he saw it, okay, himself with his eyes. And in reference to a fact which could be heard, it is the evidence of a witness who says he heard it, okay. With reference to a fact which could be perceived by any other sense or in any other manner, the evidence of a witness who says he perceived it by that particular sense or manner. With reference to an opinion or to the grounds on which that opinion is held, the evidence of the person who holds that opinion or who holds it on those grounds, okay? Now, if oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material thing for its inspection. So now we know what direct evidence means, and it's important to understand this because hearsay is not direct evidence, okay? It's indirect. Now, introduction. Section 63 of the Evidence Act of Kenya lays down the basic rule of law of evidence that to prove any fact in a court, it is the best evidence that must be produced. So this is the best evidence principle or law or rule, sorry. And such, the best evidence is always linked to the direct evidence, okay? So best evidence is direct evidence. And we gave examples of direct evidence, so I'm not going to repeat so much of that. So what is indirect evidence? So anything other than direct evidence includes things like evidence of reputation, opinions, and beliefs of individuals, okay? In order to prove the existence of any fact to which such reputation, opinion, or belief relates, okay? Unless the opinion itself or reputation is relevant. So what hearsay evidence includes the indirect evidence, okay? And that includes reputation of a person, the opinion of a person or belief. Now, hearsay is evidence of those who relate not what they know by themselves, but what they heard from others. I heard him say. So the word is hearsay. Heard someone say something about someone else. It is a statement other than one made by the declarant was testifying at the trial or hearing. So to amount to hearsay, the statement must have been offered as proof of the truth of what it states, so that if the statement is offered for any purpose other than for its truth, it is not hearsay. Yeah. So we see that in order for a statement to be hearsay, it must have been uh, obtained from somebody else declaration. Somebody else must have seen that and said to the witness what he saw. So it's not what the witness himself perceived or saw. It is or heard. It is a story of a fact that he heard from somebody else. All right. And for that to amount to hearsay, that statement must have been told as truth of a matter in question in the court. Okay. All right. So as a general rule, hearsay evidence is not admissible. All right, because obviously, because the person did not perceive by themselves. Okay, so the element of truth and the element of reliability, as well as the element of oath, because taking an oath for a witness is personal. You are swearing to tell the truth. So the essence of the oath is lost when you, as a witness, are only relating things you heard from somebody else. Okay. So direct evidence is the evidence that normally is admissible in a court of law, and hearsay is not direct. So it is the general rule is that it is not admissible in a court of law. Now, Section 63, Subsection 2 of the Evidence Act refer to facts and lay down that a fact to be proved could be seen, they could be heard, touched, tasted, or smelt. Testimony should be of one who actually saw it, heard it, tasted it, or smelt it. Okay. So put differently, the testimony must be of the person who perceived that fact through his senses. So hearsay evidence is also called derivative evidence. It's like a form of secondary evidence. All right. Um, so it's best always to get the person who perceived that fact and not somebody who heard from him. Okay, that is the general rule. So basically, it's just more explanation on the same. And another cardinal rule to exclude admissibility of hearsay is because, other than that, it takes away from the oath of the person to establish only the truth, to say only the truth. It also takes away from cross-examination in the fact that the person who heard somebody say or see something or this, it's that person cannot be cross-examined. So whoever is giving hearsay evidence, it's hard to cross-examine them because they are not the person who actually saw or heard that fact. Okay. And the most obvious, most common reason why also hearsay is not admissible is because of the fact that it's unreliable. Okay, and the court prefers the most reliable information they can get on the facts. Okay, on the facts in issue. And another reason is because the person who is the witness who is giving testimony in a court of law, the court has a standard, requires something from them. They require the witness to take personal responsibility, so that, for example, if they lie to the court, then of course there's a serious offense of obstructing justice and contempt of court. So it's a personal responsibility you are taking, and a person who is giving hearsay is not responsible for what he heard from someone else. Okay, um, and the truth, of course, is diluted and diminished, because I remember there was this. In school, there was this exercise our teacher made us do. Uh, we had like a long line, we formed a long line, and one person on the end of the line was told something. Let's say there are 5 tomatoes in the basket, and the same statement was repeated. The person repeated it to the next and the next person, all the way to the last. And when the last person was asked what the statement was, it was quite distorted, okay, and different. So it is common sense that with each repetition, statement becomes more diminished and distorted. It's not the same as the original one, the original version. Also, of course, hearsay is the same as backbiting or rumors. So what it is, it's okay, it's enforcing the rule that if somebody really saw something or had something happen, they should have the courage to come forth themselves and say it. Why tell somebody else to be the mouthpiece for them? So yeah, all right. So that's it. And also there's the question of whether the one who actually made that statement whether the one who said the origin of the story actually is a trustworthy person, they tell the truth or not. There's no way of assessing that. So those are the reasons why hearsay cannot be admissible in a court of law. Now we move on to the scope of hearsay. Now when a statement is tendered not in order to prove the truth, but simply to prove that the statement was made, then his or her evidence is not hearsay evidence, it is original evidence. If it is just the fact of the statement rather than relying on the content of the statement, then we call that original evidence. Hearsay can therefore be identified by asking a few simple questions. So when somebody said, so and so said he saw the thief break in, yeah, but it's not about, when the reliance is not on the truth but on the fact that somebody said this, then it's not hearsay, it's original evidence. Maybe it's relevant to the court to know somebody actually made a certain statement, okay, and it's not about the truth of that statement, whether he actually saw what he saw. So it's kind of confusing, and the court normally has these questions to ask itself when identifying hearsay evidence from original evidence. They will ask the following questions. Number one, was that statement made out of court instead of in court by a witness during the trial? Number 2, what was the aim of the person who made the statement? Was it to make another person believe what was said in that statement, or to make another person act upon the fact as if they are true? If neither of these were intended, then the statement is not hearsay and can be admitted as original evidence. So the court will ask itself whether the statement was made out of court, okay, instead of in court by a witness. And if it was made out of court, okay, if it was made out of court, it is hearsay. But if it was made in court by a witness testifying, then it's not hearsay. And the second test is, what was the aim of the person who made the statement? Was it to make another person believe what was said was true and to act upon that statement, believing it is true? If the answer is yes, the maker intended for the person to act on the statement, then it is hearsay. If it is not, then it is not hearsay. Okay. So that is the two-step test that the court asks itself these two questions to determine whether a statement is hearsay or not. Now, what is the purpose of admitting the statement? Evidence of a statement made to a witness by a person who is not himself called as a witness may or may not be hearsay. We saw that there was like some kind of a gray area here. It is hearsay and inadmissible when the object of the evidence is to establish the truth of what is contained. So when the objective or the aim is to say that what was indeed seen or heard or said by the maker of the statement was true, then it is hearsay. And it is not hearsay and it becomes admissible when it is proposed to establish by the evidence not the truth of the statement but the fact that it was made. So that is the gray area. And I think it's simply more explanation on the same thing, on the two-question test. It is true if the reliance is on the truth of the statement, then it's hearsay. If the reliance is on the fact that it was made, it's not hearsay. So we get a case in Subramaniam. I smiled because I know a person by this name, and his name is right here, so it was unexpected to see. In Subramaniam, referred to above, the appellant was charged and convicted of being in possession of firearms without lawful excuse. In his evidence, he asserted that he was acting under duress as a result of threats uttered to him by Malayan terrorists. When he attempted to state the content of the threats, he was overruled by the judge. He appealed against conviction, arguing that the judge should actually have listened to what the threat was. And of course, the judge would have argued that if he was allowed to say what the terrorists had told him, that would be hearsay. The Court of Appeal held that the conviction had to be quashed because what the terrorists told the appellant should have been admitted as original or direct evidence. It would have shed light on subsequent actions of the appellant. That a witness could not vouch for the truthfulness of records he did not personally generate, save for the fact that he had them in his custody, was the finding in Mayers, in which the appellant was charged and convicted of receiving a stolen motor vehicle. So you see, even judges can get confused here. So in Subramaniam, we see that the person was convicted because he was in possession of firearms without lawful excuse. When he was arraigned in court, his defense was that he was acting under duress, or yes, under duress because of threats he had received. So the question is, this person is narrating things he had from the terrorists. So he wanted to explain the threats. Maybe they threatened to kill his wife or his children, or have him, sent somewhere and tortured. According to you, is narrating what the terrorists had told him hearsay? I will leave you to think about that. So the Court of Appeal said it wasn't hearsay, it was original evidence. All right. Hi. Now moving on. Okay, they are giving even more and more examples. There are more and more examples here. So we have a case of Mayers. Mayers was in the business of buying wrecked or broken down motor vehicles for repair and resale. So he would buy broken motor vehicles and repair them and then resell them. The chief prosecution witness was the person in charge of the records department of the relevant motor vehicle factory. He testified that every time that a car was manufactured, a workman would note down the engine number and the chassis number of the car, amongst other details, and this would be marked on some card. He also testified that the cylinder head number would be indelibly struck on the cylinder head block so as to be inerasable. The card would then be microfilmed and stored. At the trial, the microfilms were produced on oath by the witness, and schedules were prepared from this microfilm. The schedules showed that the cylinder block numbers of the car in question belonged to the car allegedly stolen. The appellant was convicted on the basis of this evidence. The Court of Appeal affirmed that the conviction and the appellant appealed to the House of Lords. The House of Lords held that the trial court and the Court of Appeal improperly admitted hearsay evidence in the form of the microfilm, and Lord Reid at page 884 stated, the witness would only say that a record made by someone else showed that if the record was correctly made, a car had left the workshop bearing 3 particular numbers. He could not prove that the record was correct or the numbers which it contained were in fact the numbers on the car when it was made. The witness did not author the entry and could therefore not vouch for its truthfulness, but merely that it was made. So the gray area, or the point here to consider, is whether the statement is all the reliance on the statement or the fact is just that it happened, but not that it was true. Okay, then once you go into saying whatever was the statement was made must have been true, then it's hearsay. Yeah, so that's all. These cases are explaining that. Okay, it's all about that. So we have another case. Another case, Patel versus Comptroller of Customs. where an accused person had imported coriander seeds from Singapore to Fiji. So this one is about seeds, coriander seeds from Singapore to Fiji. He correctly made a declaration on import forms that the cargo originated from India, but when the cargo arrived, some had been repackaged and wrapped into a bigger bag written on them produce of Morocco. In the import forms, the appellant had filled the coriander to be the product of India, so in respect of the bag's written product of India, he was arrested and charged with making a false declaration in customs import forms by stating that the imports originated from India when in fact they originated from Morocco. Question arising was whether he could be convicted on the strength of the tag produce of Morocco for declaring that the coriander originated from India when it is in fact originated from Morocco. He was convicted and he appealed when it was held that the evidence of the writing on the bag was inadmissible hearsay because the court could not ascertain that the coriander had actually come from Morocco. That the bags were marked produce of Morocco was not evidence of origin because nobody knew by who and when those markings were made, and the maker could not be called to vouch for the truth of the markings. Yeah, so more and more cases. So there are even more and more cases here. There's one here which is simpler, so I'm going to try and read this one. Tenure versus Uganda. The accused was charged with being in possession of a stolen bicycle. The bicycle was seized by police officers acting on information. On examination, the bicycle was found to have a forged number plate. The accused was convicted of the offense but appealed. And on appeal, it was held that the police report from Kampala suggesting that the original number on the bicycle was altered was hearsay. It should not have been admitted because the person that marked the number on the bicycle was not called to give evidence. So whenever it is that the person who, like in the case of the coriander seeds, stamped produce of Morocco, if he is not there to say that he did or to explain, and in the same case, if the person who said uh, the if the person who said uh, who marked the number on the bicycle was not called to give evidence that the number plate was forged, then that is hearsay. Relying on the fact that it is true the number plate was forged is hearsay. Okay. So it's very important to understand that the distinguishing factor between direct evidence and hearsay is that direct evidence should be explained by the people who, created that thing, who put it, who established the fact, or people who have the expertise to understand that the statement made would either be true or false. In the case of microfilms, the person who put the numbers on those microfilms. If in case of a statement or a label, the maker of that label. If in case of a number plate, the maker of that number plate. Okay. The expert is required to be the one to testify, not somebody else. Okay. So now that we've established what hearsay is and is not, we move on to the exceptions to the general rule against hearsay. So we know hearsay is not admissible as evidence. That's the general rule. But now we look at the exceptions to this general rule. In which situations is hearsay going uh, to be admitted regardless of it being hearsay? The first situation is in statutory exceptions. Okay, so that is the first one is the person who made the statement which is considered hearsay is not available to appear in court. So where the person cannot appear himself to give the testimony or give the evidence, then it is admissible. Now, an explanation of this is statements, written or oral, of admissible facts made by a person who died. So, in the case of someone who died, he made that statement, but he is now dead, so he is not available to give it as direct evidence. Another situation is someone who cannot be found, yeah, or who has become incapable of giving the evidence, or whose attendance cannot be procured, or whose attendance cannot be procured without an amount of delay or expense which appears to be unreasonable to the court. Let's say somebody lives in the end of the world in Antarctica and you're in Kenya, and he made that statement, and bringing them all the way here is unreasonable expense to the court. Or maybe someone was suddenly paralyzed head to toe, they cannot speak what they saw, so but they were able to tell it to someone. Someone is under life support, okay, after a terrible accident, but before they could be in that state of coma, they were, you know, they managed to say who had hit them with their car, something like that. So now we know that these are the circumstances. Death, cannot be found, cannot, is not capable, has been rendered incapable of giving. His attendance cannot be procured. His attendance, if it can be procured, would cause an unreasonable expense to the court or delay the delay justice or something. Okay. Now we get a case here, Republic versus Ndolo. The court considered the meaning of cannot be found in connection with Section 33, the India Evidence Act, and Section 34 of the Kenya Evidence Act, where the language is identical. Okay. The facts were that the witness left his place of employment and was not served with a summons for the scheduled date of the trial. The trial was adjourned and assistance from the registration department was to no avail as he could not be traced. It was contended that his disposition should be read. The defense argued that had the prosecution taken reasonable steps to discover his whereabouts in preparation for the first date of hearing, he would have been available. The court held that the words cannot be found refer to the time when the witness is sought to attend the trial and does not refer to the state of affairs as some earlier period. There was no question as to whether the search had been a diligent one, and the words appear to imply that such a diligent search should be required before the condition is held to have been fulfilled. All right, so now we are breaking down those instances. statutory exemptions of admitting hearsay. We said is upon death cannot be found. So we explained with Republic versus Sundolo what cannot be found means. And now we move to unreasonable delay or expense, the situation where the person can be brought, but it would create an unreasonable expense or delay to the court. So what amounts to this unreasonable delay or unreasonable expense? There's a case here, Thornhill versus Thornhill. The Court of Appeal observed the learned trial judge also stated in his judgment that the cost and inconvenience of bringing a witness from the United Kingdom would not be great in these days of rapid and inexpensive air travel. With great respect, I disagree that air travel in these days is inexpensive, although I agree that it is rapid. But the question seems to be this: is it justifiable legally to put the petitioner to the expense of bringing a witness from the United Kingdom to testify about a fact which is not denied? And respect of false evidence, the court has a discretion to accept on affidavit, particularly as the petition is not defended and no application was made to have the witness orally examined. So when faced with the foregoing scenario, it is open to a court to admit evidence from such persons, but again, such evidence as is admissible is circumscribed to include only that evidence relating to the following things. So we have something here, and so we have like a breakdown of the exceptions or situations where admissible hearsay is admissible under the certain conditions after meeting the certain condition. The first one is dying declarations. Now, when the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question, and such statements are admissible whether the person who made them was or was not at the time when they were made under expectation of death. Okay, so this is obvious. When a person is giving a dying declaration, and that information would be relevant to establish a fact. Let's say the person who killed this, the victim, okay, the deceased, the identity of that person or the circumstances of his death, then that becomes admissible. Yeah, it's admissible. So this is admissible as an exception against hearsay, against the rule of not admitting hearsay. So it is normally assumed that when somebody is dying, they have no reason to lie, okay? So we have cases here. We have a case, Swami versus King Emperor. The court considered the admissibility of evidence by a widow that her deceased husband had told her that he was going to a particular place at the invitation of the accused wife to receive payment of his dues or wages. The court considered admissibility of the issue of whether evidence of a statement by a widow that her deceased husband had told her was going to a particular place on the invitation of a particular person to pick up payment of his dues. The statement was held to be admissible, even though it was made before the cause of death had arisen, nor was death imminent, but because it shed light on the circumstances leading to death. So any information which is relevant to the court to a fact and issue, in this case being that the court is trying to find out the circumstances of the death of the deceased, how he died, and the main question here is to establish whether maybe he died naturally or the accused killed that person. So any information that would explain the whereabouts of the deceased prior to his death or any information that is relevant would become admissible. And remember, a dying declaration requires no corroboration in evidence. Now, so there's another case here. In a case where the accused was charged with murdering his wife, the prosecution gave evidence that the accused had started a fire in his flat where his wife was confined to a wheelchair. Both suffered injury and while being taken to hospital in an ambulance, the staff had the wife say, "You have really got me now." And after they arrived at the hospital, she said, "Murder, murder." She died several hours later. It was held that the wife's words were admissible as evidence. The staff who would normally give that evidence of what they heard the wife say prior to her death is admissible in this instance, okay? We have another case, Pius Jasunga versus Republic. A witness who was an assistant police inspector gave evidence that he saw the deceased lying on the road with a wound in his chest. When asked who had injured him, the deceased replied, "Pius Jasunga has stabbed me." Later at the hospital, the deceased made a statement to the superintendent of police, during the course of which statement he got weaker and weaker and he was unable to sign the statement. So there was no corroboration of this story and it had been made in the absence of the accused by a man who was suffering from a terrible wound from which he died after. So the Court of Appeal in Kenya has stated that such evidence, although admissible, required corroboration. This clause also makes relevant the circumstances of the transaction which resulted in his death, which raises questions whether besides cause, motive spoken to by the deceased would also be relevant. This question has been resolved by the Supreme Court of India in State of Uttar Pradesh versus Ramesh Prasad Misra, where it was held that Section 33A of the Evidence Act is to be construed in a wide manner and includes a statement by the deceased regarding motive behind the criminal act. Indian courts have also held that a dying declaration can be the sole basis for a conviction. So there's also the assumption in India that there's a tendency among people who are dying to implicate people they hate, okay? So maybe someone really hates someone and maybe they died by accident or they got injured, okay, by accident, but as they are dying, they would point out the name of their enemy, their worst enemy, so the person can suffer, you see? So there's like a caution, a general caution that when the court is relying on the sole declaration of a dying person, excuse me, sorry, that person they should caution themselves. The court should caution themselves. So we are given an Indian case of State of Gujarat versus Human Singh, Karsan Singh. The dying person gave the first declaration pointing to one person, but the second and third declarations he implicated others. Okay, so this cast a doubt on the side of the courts on the reliability of this statement. So it was not acted upon. Okay, the test of the admissibility of the evidence of a dying declaration was stated as the following. So can the possibility of distortion be disregarded? So the court must ask itself whether they are sure that when the person was dying, okay, uh, whether the person who's dying, he was actually able to understand or point or, you know someone did it, and not just as a result of being uh, panicked or confused, So the condition of the person who is dying is a good element to understand here. The second is the dying declaration has to relate to the cause and/or circumstances of the death of the person who is dying and making that declaration. So we have a case in Mohammed Warsama versus Republic. The deceased had made a series of dying declarations which were precise and detailed, but which also stated the cause of death of another person. So the second test is the statement should include or should have as the main theme the cause of the death of that person who made the make of the declaration, not somebody else. So the court held that the dying declaration has to relate to the cause and circumstances of the death of the maker, not of other people. So admissible was, excuse me. So what was admissible was the part about his own death, and the rest was not admissible. So another question, the test that has to be applied is whether the statement was proximate to the death, was made as close to the dying time as possible. There should not be like a time lapse between them. So we have a case here in Antonio versus Barugahare versus Republic, in which a witness had given evidence that the deceased woman had told her 6 weeks prior to her death that the accused had asked her to marry him, and he had also asked the deceased, according to the report, to lend him money to pay his tax. She had refused to yield to either demand. The issue arising was whether what she had confided to the witness was a dying declaration. Did it amount to a dying declaration if the statement was made 6 weeks prior to the death? The court held no, it was not a dying declaration because the facts alleged were not proximate or related to the death, and the circumstances were not those of the transaction resulting in the death. Okay. So we see that the whole issue here of dying declarations, when they are admissible, when they are not. We say the first test is to make sure the condition or the state of mind of the dying person was in a in a good place to ascertain what was happening to him and who was doing it. And the dying declaration has to relate to cause and circumstances of the death of the person who made them, not some other person, okay? And it should be proximate. The statement must not have been made a long time before, so that there's no connection between the facts or the statements made then and the dying of that deceased person. So there's another case of Republic versus Kabatale in Joamba, a complaint made by a deceased person to her headman 2 days before the house in which she was sleeping was burned was held directly related to the occasion of the deceased's death and was a circumstance that resulted in her death. So we see also when it comes to time lapse, it is, we see in the case of, compare the case of Antonio of 6 weeks versus the case of the headman here, that is 2 days. So you can see that's a long difference of time. So the closer the event happened, or the the statement was made to the dying time, the more admissible the chances, the more likely the chances for it to be admissible. So there must be no special features likely to result in error. For example, drunkenness or incompleteness. So the statement must be complete to state the cause of the death and the person responsible. It should not be like uh 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 P, then you say it was Peter who, you know, who killed. No, it has to be complete made. Um, it should be complete and should not have been as a state of any intoxication whatsoever. So we have the case of Republic versus Charles Darkey. The deceased was in this case admitted into hospital suffering from gunshot wounds. When he was asked who shot him, he said, Charles Darkey has killed me. He shot me with a gun. I saw him with a gun. He was on a motorcycle. A friend of mine had visited me and I went to the garage with him. At this point, the doctor intervened and the deceased died subsequently. Darkey was charged and convicted on the basis of the statement despite his counsel's objection. On appeal, the statement was held inadmissible on the grounds that the deceased might or might not have added something, and essentially because the statement was not complete. On appeal, it was held that the statement could not be used as a basis of conviction. Had he stopped, the court said, for example, had the deceased stopped at saying, Charles Darkey killed me, he shot me with a gun, then this statement would have been admissible. Okay. So when he started explaining more about a friend had come to visit him, he went, that friend was not Charles Darkey, remember. He went with him to the garage. It implied that maybe it was the friend who maybe quarreled with him and shot him in the garage. So because of the incompleteness of the statement, or I would rather say the vagueness of it could not be admitted. So we see now how this whole thing is explained with examples. It's explaining more and more about dying declarations, okay, and the other exceptions we mentioned, and other exceptions which we haven't mentioned, yeah. So it's we'll stop here for today. It's very interesting to see uh, that the court really breaks down these very minute details, and you see them everywhere reflected in these cases. So nothing in law is cut and dry. Like there's always a gray area, there's always an exception, there is always a case where one statement can be admissible and another that looks almost the same, but because it was under different circumstances, it could not be admissible. So this is all very nice to understand. I hope you had fun reading with me today, and we'll continue from page 120 next time. If I would have not read this by myself, we'll continue from here. Otherwise, we'll tackle a different topic. You can read on your own. So, all right. See you next time. Thank you.